All right, here we go. Hi, this is Kurt Barone,
And Brad Pinsky.
and we're here for another edition of File Law Roundup for February 24th of 2025. Brad, go ahead.
All right, let's start in Florida. We're gonna have a bunch in Florida. It's like almost Florida week this week, but
There
we're gonna
are certain states that seem to have a lot more cases. Now, Florida is one of them, but I think,
LA.
well, California in general, but you could call LA its own state. What was Pennsylvania? When I did the last analysis of my database, the number one state was Pennsylvania, believe it or not.
Wow.
Now, I
Wow.
don't know if that still is the case. That was a couple of years ago. But I should do that again. And I was actually thinking there are so many cases out of FDNY because a lot of them are in state court, and I don't have that. I think somebody could do exactly what we're doing just on FDNY.
No
I
question.
swear to God,
No
there's
question.
just so many cases out of
And there's
FDNY.
more stuff this week and more news this week. So, but look, big cities,
Yeah,
big problems. I mean,
yeah.
that's really the answer. It's easy to corral a small staff. It's difficult to corral a big staff. So, okay. So in Miami, we have this is sad and unfortunate, and you could replace this with so many others in the past. You might as well call this Lairdsville, New York,
Yeah.
right? It is exactly, I mean, to the letter, exactly the same as Lairdsville. So
Well, we've got one even closer. There was one in the UK where, and it was an incident, but the incident commander was charged with manslaughter, and his son was killed in the fire.
oh, okay.
And I
Same,
think
same with
that
Lairdsville.
adds that wasn't present in Lairdsville.
No,
Um,
Lairdsville was the chief's son. One
but
one
but
of the two
he
died.
wasn't at the scene,
One,
and he wasn't charged. It wasn't.
oh, correct,
It's
correct.
like the indignity of losing your son
And then we
or
charge you
daughter,
for it.
but and then being charged criminally with it. It's
Right.
just
So now that we've confused everybody watching,
yeah.
here's what happened. And we're going on discussing it. So two Miami-Dade firefighters conducted a live fire evolution in an acquired structure, which I think itself is against the policy of Miami-Dade Fire Department. And it's unfortunate because not unfortunate choice they made, but it's unfortunate that using acquired structures today is so problematic. I mean, it takes an amazing amount of resources, but it is the best training. It's just unpredictable and dangerous. Nonetheless, here it keeps going from bad to worse. But the allegations are that a father and his own son, who was an EMS worker but not a firefighter, I don't think had any fire training. They put him into a building during this exercise with live fire, and they're hoping to give the son some reliable training. But two brothers were left unattended on the third floor, directly next to the fire. That's the allegation. So they've charged the father, charged two, firefighters, one of whom at least is the father, who lost his son, Cameron, or lost. The son is Fabian
Fabian, yeah.
Camaro. In any event, they charged the father and one other for conducting this evolution. I don't. This is very tough. When Lairdsville came out, and for all that don't remember, this was in 01, 01 or 02, early or late
One
or
right
the
after
other.
9/11, yeah.
Yeah, and they conducted a live fire evolution with using two victims who had no SCBA or firefighter training. They nailed them into a room, literally nailed the board shut, had a small opening, and when everything went up very quickly, they were forced to try to find their way out or bash their way out of a window and jump out a second-story window. One dying, one severely injured. But here's the point about that. There were all of these. There's a video on it. You could probably pull it up on Google. New York State Office of Fire Prevention Control did it with some very well-known, both New York and national. Goldfeder's on there. I mean, there's a lot of people talking on there and saying how bad it was that they're being charged in this case. But that was different because the deputy chief, Alan Baird, who was charged or prosecuted, he didn't set up the evolution. He oversaw it but he didn't set it up. It was kind of handed to him. Here, these guys violated department policy allegedly and conducted the evolution, but it's so similar. And I guess here's my point: as opposed to Lairdsville, where everyone expressed their shock at how come we're charging somebody here, I don't know if you take away the fact that they're family, you would be doing the same thing. You'd be charging them, I think.
Well, I think I don't understand the prosecutorial discretion. Or let me go beyond that. I don't understand the exercise or the lack of exercise of prosecutorial discretion here to not charge him. I mean, what are you trying to accomplish? Is there someone who needs to be deterred from doing this again?
Oh,
Um,
yeah.
like what is the purpose of punishing these men under these circumstances? Somebody robs a bank, there's a need to punish them. There's a need to make sure that, seriously, um, I think it's a failure of prosecutorial discretion. And I felt the same way in Lairdsville, and I felt the same way in a number of other manslaughter cases where firefighters were charged, including Aurora, Colorado.
Yeah.
Is there a true need to vindicate this person's death beyond what the civil liability system
And I'm going
permits?
to throw my 2 cents of that because I agree with you. And this is where we always talk about the court system is not our mentality. So you have
Mhm.
to split off the judiciary and the enforcement prosecutorial from the firefighters' mentality. I believe if I was to ask these guys, I don't know them from a hole in the wall, but if
Mhm.
I was to ask them, did you think what you were doing is dangerous? They're like,
Yeah,
no, we're going to light a small fire.
yeah.
We've got them. We got a hose. We have safety lines. We have whatever they had. I don't know. Right.
Mhm.
But we tend to think as firefighters, lighting a room on fire is not a big deal. Right.
Right.
It's not going to get that hot. Just keep your mask on. Just keep breathing. You'll be fine. We got you.
Mhm.
And so when you talk about was it so highly likely, reckless, right? Reckless endangerment, was it so highly likely they were going to get killed or severely injured? If you ask most firefighters, they're like, no, it's just now I don't know what they lit on fire, but assuming they did a single room burn with the proper four, panels, and I'm making a lot of assumptions, but
No, and I read several articles about this, and there's some articles say one thing, some articles say another. But one of the things that's similar to Lairdsville was there was in one of the articles I read that someone had poured a little bit too much accelerant.
Hmm.
And that is what happened. That was a contributing factor in Lairdsville. And there's also a factual question about who was it that poured
yes, that was the issue in Lairdsville because it never
yeah,
really came up, but
right.
it should
But
have
but
come
I
up.
I agree with you. But again, in the class I'm in the forensic psychology program at Arizona State, and I've taken classes on punishment and on really what is the role of the psychological role of punishment and on the criminal side, because let's face it, particularly under the Biden administration, there was a movement to let a lot of people out of prison
Yeah.
because what they did, it might have been wrong, but do we really need to criminalize this?
Right.
Is it really, and in a sense that we've over criminalized things in the United States? And I don't know. I just think that this would be exhibit A here of the fact that this should not be criminal. Not as the facts as I see them. Is it wrong? Absolutely. Should these guys have been disciplined? Absolutely. Should there be some civil consequences? Absolutely. But do we need to use the mechanics, the infrastructure of our criminal system to address this?
Right.
I don't think so.
Yeah, because I agree with you because I don't think the mentality of the chiefs, right, of the firefighters running the evolution was to hurt anybody. I think from our point of view, come on, a single room fire, and I'm making the assumption that it was, or was intended to be.
Right.
We just don't look at that as dangerous. We just have a different mentality. So
Yeah.
it, they weren't trying to do anything but that was so likely to cause injury. But on the other hand, the
Mhm.
DAs have got to be saying, you know what? If we don't do something about this, this is going to happen again.
Yeah, the fact that they're going to be fired the fact that they're probably going to be held liable for over $1 million in damages and harm and everything.
And
The
oh,
fact
bye,
that
they don't have a
the fact that it's
child.
your own son, that
Yeah.
apparently isn't enough of a deterrence. We've got to put you through the criminal system. I don't think so.
Yeah.
I don't think so. But again, maybe I would feel differently if I was closer to the case than I am. But
maybe.
I don't know.
I guess the question is, ask the mother how she feels. I'd be curious.
And I think that's, and you don't know, and that could be, a factor here. I don't know, but I just,
Right.
I don't know.
But
I don't
but
know.
the
I don't know where
point
we're going when we're criminalizing this. I felt the same way about Aurora, Colorado. What they did was wrong. Absolutely, they should have been disciplined. Maybe lost their job or whatever. Certainly consequences, but really in jail, really.
Yeah, I know. That was the whole hype. That was the woke hype.
And again, just to go back to what we're learning in school, we have more people in jail, in prison, than Russia and China combined.
Well,
Okay. So what is wrong with our criminal justice system? Well, one of the things is we're over criminalizing things. We think that we've got to make something a crime in order for people to be deterred. And I just don't, I'm not buying it. And this is to me a lack of prosecutorial discretion.
I'm more akin to, why don't you put the shoplifters in prison once,
You know,
deter that, right? Because that
People
they're going to
break
keep
into
doing
cars,
again.
they take something, they're going to get like $20. They're going to steal something out of a car for $20 and they do $5,000 worth of damage to the car, breaking in and all that.
Right.
Why don't you go after them?
Right. Okay, let's stay in Florida. Let's go to Palm Beach. This is also I think a really interesting one. So we've got, and this is going to be a little confusing, so I'll step everyone through it. So we have the Court of Appeals, the Federal Court of Appeals for the 11th Circuit. They upheld, meaning they affirmed, they agreed with a trial court decision, the second trial court decision in this case, holding that the Palm Beach County Fire and Rescue did not violate an individual's First Amendment rights. And what he claimed is his First Amendment rights were violated because you disciplined him, a fire captain, over remarks he put on social media back in 2018. But in truth, this is not really about speaking. This is about false speech. And so the whole question, I'll give you the facts. The whole question is not whether what he said is really protected by the First Amendment, because it's not speech if it's defamatory or if it's untrue. Same with it, right?
It's not protected speech.
Not protected speech.
Right.
But same with hate speech. The Supreme Court says, like, hate speech is not speech, right? Untrue speech is not speech. But the point is, it's not protected by anything. It's defamatory. So in 2019, there's a suit because the captain received a mere written warning, right? This is one of those things, like, why would a lawyer take this unless the guy's got a lot of money willing to throw away?
Or a relative that's an attorney.
But I mean, this had to be $150,000 of attorney's fees. I mean, this is a lot. This is four court appearances, 3 or 4 court appearances. In any event, so he claims that he was he made a post, a critical post. He was critical of a union official, right? And unions are not part of the fire department. So it's not like he was being critical of the fire department. He was being critical of the union. He receives warning because the allegations he made, they claim you knew were untrue. It was not a true statement you made. It doesn't matter what it was. It was about taking comp time and vacation time or whatever. In any event, first he loses at trial, but then takes it to the appeal. The appeals court sends it back to trial court for a determination on the question, really, of is what he said true or not? And the jury was asked to say, not to determine whether it was really protected speech. That's a legal question. They were asked to determine whether the comments knowingly false or were they not knowingly false? And the jury comes back and says they were knowingly false comments. That's a question of fact for a jury. They didn't believe the plaintiff that, of what he claimed he said and why he said it and whatever, what he knew. That was the big part, what he knew about whether his claims were untrue or not. And the court, the appeals court basically just said, look, the jury is the fact finder. They get to find what they find. And that's the end of it.
Yeah. It's not if what you're saying is not true, and again, I think it's debatable. The jury found that it was not true. I'm sure the plaintiff, O'Loughlin, feels that he was factually accurate, or he did not have knowledge that what he was saying was false. And you get into that New York Times standard about you got to be reckless with regard to the truth, knowing that what you're saying is not true, or reckless with regard to the truth or falsity. And the jury concluded that he was. So, wasn't, in some respects, it wasn't really a First Amendment case. And it certainly wasn't an issue about the social media policy. It's whether he could be disciplined for, that kind of false speech. And,
the question I had, which was interesting, is he's talking about a union official.
He was running for office, by the way.
Who was?
The plaintiff. The plaintiff was running. The plaintiff was running for union office, and he was criticizing another person who was running for union office. So, But
that's the point. Yeah. So how does the fire department get to punish him for making comments about someone who's not in the fire department? He was making comments about the union. That's not fire department business. Right. That would have been my argument.
Right. But as you said, it's not protected speech. So if it's First Amendment, you could make the argument he did it as a private citizen. He did it as a union member and as a candidate. Okay. It's not work-related speech, but you could, and that one is factually, arguable. And then you have this issue of a matter of public concern. Is it not? Well, depending on how you define the public, it certainly is of concern to the union. Okay.
But how is that a fire department matter? Such that the fire department can punish you for what you said in your capacity as a union official, union candidate about another union person. It's not a fire department matter.
Well, I think that it is, because one employee is accused of disparaging another employee. And unfortunately, as much as we might want to wish it was not a fire department problem, I'm sure as when you were the chief, you have one employee who's saying he said this about me. And I'm familiar with a number of problems, including some sexual harassment allegations that involve off-duty firefighters harassing another off-duty firefighter. And there's a factual question. Is it work-related? Is it not? Can the department address those kinds of allegations, or can the fire department just sit back, allow someone to be harassed and just say, oh, well, it's all off-duty, we can't do anything about it?
Maybe the tie is it's not work-related, but the comment was about a alleged work-related violation. So even though you're trying to beat him up as a union candidate, not work-related, you used a work-related allegation, right, as your off-duty conduct, which is kind of interesting. It's kind of right on the line.
There is. And again, it's a difficult area. And again, the case I'm thinking of involved a female who was being clearly sexually harassed by colleagues off duty. And we saw that in, the Fairfax County case as well. That's a slightly different fact pattern. But this one, it's very clear. People are in their own name, clearly posting things that are harassing about a female colleague. And but is the fire department powerless to do anything? No, I don't think so. But some of it's going to depend on the wording of your policies. Right. And you want to make sure, I know in our policies that we cover that we're not going to say you can't harass anyone off duty. We don't want you harassing anyone on duty. Okay. We're not going to say you can't harass anyone. You want to harass your neighbor. We don't like it, but that's not prohibited. But you cannot harass a fellow firefighter on or off duty.
Right.
And that we will consider that to be a rule violation.
And that's true with sexual harassment as well.
Absolutely. Absolutely. So that's a missing component in some well-known fire department policy uh, narratives, okay, and we'll leave it at that. But some policies do not go to that length, and I think that they're going to find themselves in trouble when they try to address that problem.
Right. Which is why people should be subscribing to must-have policies. So we are current with, right? But I mean, that really is it. This, which provides so much of the basis for the policies, what's happening today, what's happening, right? I mean, it's
Well, I think in some of these other firms, they have attorneys that look at the language and say, "Oh no, you can't say that." And yeah, I know, and they're not thinking, they don't have the insight that we have here with regard to what does a fire chief need to manage the department, and they're thinking, "Oh no, we don't want to put that in there because we could be held liable." Yeah, I
avoid
know.
the problem in the first place, right?
Yeah, really, seriously.
Okay, so let's go to Georgia. We're just staying down south for the moment.
Yeah.
We have a battalion chief who, with the Covington Fire Department, has just filed a suit. So these are just allegations. He was terminated last year, and he claims that his rights to due process, hearing, notice, know what you're charged with. He claims primarily the breach of due process. He also claims a breach of an employment agreement, which is interesting because those are sometimes kind of opposite competing allegations, right? If your employment agreement says, here's how you're punished, well, then that may not be due process, but you're allowed to waive those rights. Anyway, a little off topic. So, and he claims his right to privacy has been violated, and as a result, he has he was intentionally inflicted with emotional distress, he claims. So he sues the fire department. He claims that the city has violated several policies in how they handled his termination. He was supposed to get, he claims, 5 days notice. He was supposed to have proper signatures on the form. He was supposed to have a decision made by the fire chief, not the mayor. He was supposed to have attempts. He was supposed to get an opportunity to correct problems. He was supposed to get the normal procedure. He says, I should have been given and this is a quote, the normal procedure, which he never got. And some of the charges, he says, were inaccurate, and the discipline as a result was inaccurate.
There's an interesting aspect to this. And the allegations, I don't know if they're true or not. I don't know, any of the details behind the scenes, but he's accused of apparently exchanging private images with someone. With a consenting adult. So there's no allegation that he was harassing someone. There's no allegation that he was doing something illegal or quote unquote inappropriate. But or I'm sure the mayor thinks it's inappropriate, but from what I gather, there was nothing, there was no objection by the recipient. Now, how the picture got beyond the one person it was sent to, that remains a question. But interesting.
This is a First Amendment case. That's what gets me.
Interesting issue here with regard to the Electronic Communications Privacy Act. The Electronic Communications Privacy Act says that if something comes, it becomes basically evidence in a case, and it was not properly authorized through the Electronic Communications Privacy Act, it cannot be used in evidence. All right. And that's an important aspect. It's another reason why, fire departments need to have a good computer policy. But depending on how they got access to this, it's possible that even if the picture was, somehow spread, if it was accessed in violation of the Electronic Communications Privacy Act, it cannot be used in evidence.
Right.
And so now they've got to prove that he did something wrong, but they can't produce the evidence. But bottom line is, if person A sends a private picture to person B, and your employer finds out about it, what rule violation is that?
As long as you're not co-employees or subordinates in any way.
Right.
If it's just your employee and some person you don't know has no relation, that's not their business, so long as it's not a crime. Right. Yeah. If it's a crime, different issue. Right. Like the fire chief who goes and picks up a female and his chief struck just kind of convince him. But yeah, what's the crime here? What's the harm?
Again, I'm not sure, but when the mayor, and I guess apparently the chief didn't feel that it warranted, and that's an important thing. When your rules and regulations say the fire chief makes the determination,
Right.
and the chief says, I think we can keep them, and the mayor goes, no, you're not. Now there's a question about if the chief is the one that's authorized and he has said you can
No.
stay,
Right.
you've got that question too. So it'll be interesting to see how this turns out. Georgia courts are not overly helpful to plaintiff employees. So, if it was, I think in New York
New
State
York,
or,
he'd be a slam
you know,
dunk. Yep.
yeah,
Yeah.
yeah, but I'm not sure how Georgia's going to handle that.
And of
So,
course, we haven't seen the response from, as always, we say, we haven't
yeah,
seen the response from the department. So they could
absolutely.
come out with being like, what are you talking about? That's not why we fired you. That had nothing to do with it. Right. I mean, who knows? Who
Right.
knows? Um, okay, let's go to Pennsylvania. This is
Mm.
unfortunate again. As we start talking about PA before, we've got 3 firefighters, all young, 23,
Yeah.
21, and then 16 years old, charged with setting multiple fires at the end of 24. They had a brush fire, a shed fire, and an old railroad building. This is problematic. This, right? But I have to tell you, I don't know if arsonists are becoming more of a trend, but I think the impatient, because what I'm seeing is people are calling in a lot of false alarms, maybe
Mm.
not going to the point of arson, but they're trying to get the excitement, the hype of the response. So they just call something in so they could knowingly respond to something and they're
Mhm.
bored. And we are seeing more of that, even in my own practice. And it hasn't, some hit the news. Last year in Long Island, one of them hit the news with somebody starting a lot of fires in Suffolk County. And then you and I covered one where people were calling in false alarms. I don't know if it's any more frequent or we're just seeing them reported more, but it does seem like young kids are getting bored.
I think it's an ongoing problem. I can't cover all of these cases. There's too many of them. And I joke, and maybe I guess I can let the cat out of the bag here. When I can't find something else to blog about on a given night, I'll just put in volunteer firefighter arson and I'll find 2 or 3 cases. It's that prevalent.
Wow.
And
Okay.
so, yeah, it's unfortunate. There's a lot of different aspects to it. Some of it could be the people that are being attracted to the fire service, which is something that we've got to be mindful of. But also, I think there's a number of departments out there that are struggling to set up a parameter around activity level and commitment to the department. And you say you've got to make 20% of the runs, you got to make 10% of the runs, or you've got to make so many, or before you get off probation, you've got to go to at least 1 working fire or 2 working fires or whatever it is. And people today, their time availability in many places is just not there. So if somebody really literally only has Tuesday and Thursday nights from 6 o'clock till 10 o'clock to be a firefighter, and they've got to get 2 working fires in before they can get off probation, it creates a situation where there's too much temptation there. And I think the department's got to kind of take a step back and look at that and see whether or not they're creating an environment that's not purposefully encouraging people, but the end result is that folks are feeling like the only way I can have a fire between those hours is, if myself or one of my friends sets it. And another point here, it sounds like from what I read that it was the 16-year-old that rolled over. In
Sure.
the old law school analogy that we make to conspiracies
Right.
is that, it's like you're everybody's in a canoe and, everybody's going down through rough water and you're all fine as long as everybody stays in the canoe. But all it takes is one guy to panic and get out of the canoe. And so, in these kinds of multiple firefighter arson uh, conspiracies here, it looks like the 16-year-old was the one that kind of rolled over
And they
and
could have just said, listen, if you roll over, we won't charge you as an adult. Otherwise, we'll have you charged as an adult.
and and
But
that
that,
that that may very well have been what happened, but
right, I'm just guessing, who knows? But, but that's one of the problems with juveniles, because I don't know about other states, but New York does an arson background check, but it will not pick up anything that was a juvenile. So your juvenile
yeah,
fire setters, your true arsonists,
yeah.
right? People who start young, we
Mhm.
can't even know about. And that is such a failure in the system.
Yeah. I get the idea that we've got to protect juveniles because kids make mistakes, but at the same time, you know, there
Doesn't
ought
mean
to
you
be a
belong in a
way
fire department.
when it comes to the fire department and it comes to fires, there ought to be
Yeah. Okay, so our last, but it is absolutely the highlight case. This is a great case. As Kurt and I started talking about, oh, by the way, I want to say something before. So one of our next policies going out to our policy subscribers, because I'm finishing it up, I'll send it to you soon, is on crimes. Which crimes are not compatible with the fire service, EMS service, right? And I've looked at many other states to see what they do, and we've kind of brought a lot of states together, and we're going to have a policy on what's not compatible, because without a policy, how do you say, well, you stole a pack of gum last week, you can't be in people's houses? How do you do that without a policy? So there's a good narration on that, but that's one of our next videos to go out in March. Our February ones will go out. Okay, so now we're back in Florida. This is a great case, and it should cause people to relax a little bit, right?
That's why I included it.
Yeah. And you and I have noticed that there's been a significant over the last 3 years, let's call it the George Floyd era of cases, right? Aurora, where we're seeing ketamine being used for proper or improper purposes. Here we have a really good court analysis of what I think is almost universal. I think this is a very good discussion. And so here's what happened. Let's go through it slowly for people. So we have a civil rights lawsuit that was brought against the police officers and the firefighters. This suit has now been dismissed. Now it's dismissed at the district court, the lowest trial court. So they could appeal it. But so what the claim is by the plaintiff or the person suing is that the firefighters and police officers physically subdued him and administered ketamine to knock him out, to violate his civil rights, right? Take his right to freedom away, basically. But the short of what happens here is EMS goes first. EMS encounters a violent, unruly patient, and they call for the police. The patient, when they put him on the stretcher, starts threatening physical violence if they touched him. And in fact, he had a very recent history of physical violence. They also know he has psychiatric disorders. He's known to be combative. And the evening prior, this is what I was talking about, he was recognized as being an individual who was armed with a knife and acting aggressively towards patrons in a convenience store. So this guy's a confirmed danger. And in fact, he says to him, he says to the EMS, if you touched me, or if you touched them, they would wrap them up like a present, signed, sealed, and delivered, and he would F them up. I took out the whole word. So the police come, they don't do a George Floyd, right? They don't kneel on him. The court very specifically goes through that. They're not kneeling on him to cut off his breathing. They're not doing all these things. And I think the court intentionally makes that point of how they didn't act, which is a little weird, or not weird, it's a little abnormal, but I thought it was important. In any event, the guy's got no real injuries. He wasn't hurt. In fact, he was protected. And so the court goes through the tests. And here's what they say. The record shows that the defendants, police officers and police and fire, were on the scene requested a medical emergency, specifically at the fire rescue's request for assistance for a combative patient. The plaintiff, who claims he was assaulted, experienced a medical emergency, and that rendered him incapable of making a rational decision. The court finds. And the court finds that when the defendants arrived on scene in response to rescue's call, the police arrived. Plaintiff was lying in a field. He complained of internal bleeding and aggressively resisted the rescue's efforts. So they involuntarily examined him because he had no ability to consent or refuse, implied consent. See, the stuff you'll learn in basic EMT class really is real life stuff. They find he has a history of psychiatric disorders. And then the court says this: under these circumstances, the record indicates that that plaintiff was experiencing a medical emergency that rendered him incapable of making a rational decision under circumstances that posed an immediate threat of serious harm to himself or others. And even if this court were to find, the court says, a Fourth Amendment violation, it does not find that plaintiff's rights were clearly established. And he would have to have a clearly established right in these circumstances to have had it violated. But so they dismissed the case, say no Fourth Amendment violation, no constitutional civil rights violation. But here's what gets me. What the court, we don't see in the decision at least, I'm curious, did the court look at a policy of the department to say, and the administration was consistent with policy? Because not every state allows you to use ketamine to subdue a patient. Some do, not every state does. So I don't know whether this region, Florida, allows it or not, but I thought there would be some discussion of it, that policy permits it.
The case was brought by the plaintiff himself. So we had a pro se case, and I think if he had been able to obtain counsel, that may have been an issue, but it wasn't raised, and the court didn't feel the need to go there. So
probably exactly why. But I think that sets a really good standard for people, because I have heard it just like you've heard it. People are nervous about giving ketamine. They're nervous about sedating people. They're nervous about helping the police now. And that's out of all of the cases, right? The Floyd, Aurora, all that. And people are nervous about it to assist the police, as they should be. But this shows you shouldn't be when you're actually doing it for the patient's benefit, not for your sole benefit, but for the patient's benefit who needs that approved protocol, sedation. That's right. Follow the protocol when you're allowed to do it when it's actually needed, and you shouldn't be in any trouble.
And I think another important aspect of this, and it's a tribute to the state of Florida, is that they have that Baker Act. And that Baker Act clearly authorizes law enforcement to take somebody into custody, really protective custody. That's really what you're talking about. I'm not sure Colorado. I didn't follow.
New York has it. Massachusetts has it. I know a couple of states that have.
Does Colorado?
I don't know.
And again, that was the Aurora, Colorado issue. But I think that certainly the unions and the chiefs out there that are listening, this may be something that if your state doesn't have that kind of a law, you may want to start, adding to your, your advocacy at the state house.
Oh, I found. So Colorado has a law on M1 hold. It can last 72 hours, and they can take someone into custody if they appear to have a mental illness and are a danger to themselves or others.
There you go. So, I mean, that should certainly be. Now, I don't know if factually that would have applied in that situation.
Well, he's threatening somebody. He's threatening the EMTs, so that might do it.
Well, no, this was in the Aurora, Colorado.
Yeah. There, no, he's threatening maybe the police, but
yeah. So that's the factual question. But again, I think that you're absolutely right. Do your EMS policies, do the state protocols, and then your local protocols authorize the use of ketamine to subdue someone who would fit into that sort of statutory taking into custody or protective custody act. So, but it's funny, when I was reading the case the first time, I saw the expression Baker acted, and I'm like, Baker acted? Yeah, it was Baker acted. And so now I'm trying to say, what the heck is Baker acted? Did I miss something? Or is that somebody's first name and last name? Was his last name acted? And then I had to go back through and I said, oh, the Baker Act. Okay. So what they said, the process of taking somebody into custody is the person has been Baker acted.
Yep. Makes sense. But I think that's probably a fairly common standard. Interesting, in Colorado, I just noticed even the EMTs can do that to somebody, which I've not seen that. I'm not saying it doesn't exist anywhere, but I've not seen that. Usually it's the police or somebody with a physician's order.
Yeah.
I haven't seen EMS be able to do it on their own, but anyway, that's it for the week. Some really good stuff.
Yeah. Another interesting week. And let's see, next Monday, I'm going to be in South Carolina. I'm lecturing Friday, Saturday, and I'll be traveling on Monday. So we'll have to work out something, but we'll either do it Sunday night or maybe Monday night. Maybe we do it later. I should be home by mid-afternoon on Monday. So. All right,
Okay.
and that's going to do it for another edition of Fire Law Roundup. We'll see everyone next week.
Take care, everyone.